Ready? Start. The tribunal opened that the matter was pending since 1981 and there was continuous probe going on since then. The opposite parties submitted the counter affidavit and reiterated that the petitioner was asked to explain on 23/7/1981 regarding loss of items and he could not furnish any defense and could not explain as to why there was shortage of articles. The allegation of the petitioner that no inquiry is pending is baseless. He was probed regarding loss of items since 1981, much before his retirement. Since the proceedings were pending, benefits except reduced pension were withheld due pending recovery of the value of the government stock and TNP detected against the petitioner. The petitioner contention to the contrary are false. The petitioner could not justify as to any item regarding which show cause notice was given to him. Hence, there was no need to permission under section 351A of Civil Services Regulation since the inquiry initiated as back as 1981. Before the trial court, pleadings were exchanged between the parties. According to husband, the wife ever since her marriage would leave her matrimonial house on flimsy grounds and such conduct of her has inflicted mental cruelty upon him. It is also stated that the wife for no good reason has refused to perform her matrimonial obligations and deserted him. The wife, on the other hand, has denied the plaintiff averments and it is stated that she was regularly harassed by her in-laws, but considering the fact that there are two daughters born out of the wedlock, she is willing to live at her matrimonial place. Various other grounds have been stated in order to demonstrate that huge amount was spent in the marriage and that she was being harassed for arranging dowry. According to wife, she was virtually thrown out of the house while she was in advanced stage of pregnancy and the plea of desertion was therefore termed to be false. Wife consequently has strongly opposed the plea of divorce sought by the husband. On the basis of respective plea of the parties, trial court framed issue as to whether husband is entitled to a decree of divorce on account of cruelty on part of wife and other issue was with regard to the relief to be granted. The husband has appeared in support of his case as PW1 and has also filed various documents relating to family health plan, life insurance policy, salary certificate, etc. The defendant wife has also appeared in the witness box and her statements was recorded as DW1. Father of wife has also appeared as DW2 and various documentary evidence were also adduced. Trial court on issue number 1 has recorded a finding that marriage was performed between the parties out of which 2 daughters were born. So far as plea of cruelty is concerned, the trial court has considered the respective plea of the parties and also evidence adduced to return a finding that wife had not perpetrated any cruelty upon the husband. The court has further noticed that PW1 in his statement has stated that he has never made any complaint or protest against the wife with regard to any act of cruelty against him or his parents. The trial court also took note of the statement of husband during cross examination that his wife never ill treated him and no act of cruelty was performed against him. Court below noticed that absolutely no good ground has otherwise been brought on record by the husband to seek decree of divorce. Since no reasons have been put forth by the plaintiff appellant to seek divorce and his plea was otherwise not covered within the ambit of Section 13, as such, the court has dismissed the suit. Trial court has further taken note of the fact that during pendency of Section 9 proceedings, suit was filed by the husband for divorce and there was no justification for the husband to simultaneously seek restitution of conjugal rights. It is therefore clear that under the guidelines of the Reserve Bank of India, the payment under the OTS had to be made in any case within 1 year of the settlement and that too were required along with interest. We may also record that under the letter of the bank dated 22/8/2006, it was properly communicated that the money in its entirety under the OTS has to be deposited by 20th September 2006, which time limit fixed by the OTS was never complied with. The OTS between the bank and the petitioner would be binding only if the terms and conditions as agreed upon with open eyes between the parties were complied with. It was therefore mandatory for the borrower or guarantor to deposit the entire money in terms of the OTS by 20th September 2006. Source is 3P Legal rhc, exercise number 31. Words are 796 and speed is